Child and Family Protection Bill committee stage.
I declare the House in committee for the consideration of the Child and Family Protection Bill.
Mr. Speaker.
Mr. Chairman.
Members, the House and Committee on the Child and Family Protection Bill.
Point of order.
Point of order, the Honourable Nathan Guy.
Mr. Chair, I seek leave for all provisions of the bill to be taken as one question with multiple calls.
Leave is sought for that. Is there any objection? There is no objection. The question is that clauses 1 and 2 plus parts 1 to 3 stand apart. The Honourable Nathan Guy.
Mr. Chair, I think it's worthwhile making a few introductory remarks about this very important Child and Family Protection Bill. It builds on the government's existing policies and legislation dealing with serious issues to do with domestic violence, and it ensures that courts can act to protect children and families from all kinds of violence and abuse. It also addresses the risk of children being wrongfully removed from New Zealand. If I could take a little bit of time to move through the important aspects of this bill. Particular Part 1 amends the Domestic Violence Act of 1995 to provide for greater protection of the child victims of domestic violence and to improve court processes. The committee recommended amending Clause 6 to provide that the protection order would automatically continue for the benefit of a child of an applicant's family, irrespective of their age, while they continue to live with the applicant. This removes the onus on young people still living with the applicant to apply to the court for continued cover. Clause 7 reenacts Section 54 of the Care of Children Act into the Domestic Violence Act, which enables the court to make interim care or contact orders to protect the welfare and best interests of the child where a protection order has been made. Clause 8 enables a registrar to amend the direction to the respondent to attend a stopping violence program by specifying a later date or different place. This will help, for example, in cases where a direction to attend a program is served on a respondent too late for the respondent to attend on a specified date. The bill also extends the period of time a respondent has to object to attending a program from 5 days to 10 days. Clause 10 and 12 clarify the transition between temporary and final protection orders by ensuring there is no opportunity for a lapse between the temporary order and the final order. The Select Committee recommended that the provision is amended to explicitly allow a lawyer appointed to act for the child under the Care of Children Act and any person whom the family court judge permits to attend the review of contact arrangements, and that's in specifically to Clause 13. To address any uncertainty about whether a judge needs to specifically discharge a temporary order when making a final order, Clauses 14 and 15 clarify that the temporary order is automatically discharged. Finally, on Part 1, Clause 16 enables a lawyer who is appointed to act for a child in guardianship or parenting order proceedings under the Care of Children Act to be present at the hearing of proceedings under the Domestic Violence Act involving that child. Part 2, Mr. Chair, amends the Care of Children Act 2004, provides for enhanced consistency between the Domestic Violence Act and the Care of Children Act in regards to psychological abuse and reduces the risk of children being wrongfully removed. The amendments introduce the concept of psychological abuse into parenting orders, the applications, but only where a protection order has made against a respondent on the grounds of psychological abuse. The Select Committee recommended widening the definition of a protection order to include those made by sentencing judges in the criminal courts on behalf of victims as enabled by the Domestic Violence Enhancing Safety Act. Part 3, Mr Chair, specifically amends the Adoption Act. Mr Chair.
The Honourable Nathan Guy.
Thank you. Part 3 specifically amends the Adoption Act of 1955. It creates a new offence under the Adoption Act of 1955 of improperly inducing consent for the adoption of a child to be punishable by up to 7 years imprisonment. New Zealand has ratified the United Nations Convention on the Rights of the Child, but it is among a minority of countries that have not ratified the second optional protocol on the sale of children, child prostitution and child pornography, the optional protocol. The proposed new offence contained in Part 3 of this bill is the last legislative change necessary to enable New Zealand to ratify the optional protocol. Clause 32 also provides that the offence is punishable by imprisonment for a term not exceeding 7 years, and that there will be wide extraterritorial jurisdiction for the new offence. This means that even if the offence occurred wholly outside New Zealand, New Zealand may still bring proceedings if the victim or the person to be charged is a New Zealand citizen or resident, or if the person to be charged has been found in New Zealand and has not been extradited. The Select Committee recommended amending the proposed new offence so that it applies not only to individual people but also to agencies and body corporates that are involved in inducing consent to an adoption.
Mr Chair.
I call Lynn Pillay.
Thank you very much, Mr Chair.